Good morning, everyone. Welcome to Assembly Judiciary. Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen. Here. Assemblywoman Considine. Assemblywoman Gallant. Here. Assemblyman Gray. Assemblywoman Hanson. Here. Assemblywoman Hardy. Here. Assemblywoman LaRue Hatch. Assemblywoman Marzola. Here. Assemblywoman Mosca. Here. Assemblywoman Newby. Here. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong. Present. Assemblyman Urick. Chair Miller.
Here. And please mark Assemblywoman Considine present when she arrives, and Assemblyman Gray and Assemblywoman LaRue Hatch present when they arrive. And with that, again, I'd like to welcome everyone here in Carson City, as well as those in Las Vegas. Good morning. And anyone watching online. With that, just a few reminders is that we will have a public comment at the end of today's hearing. Please make sure you turn the volume down on any of your electric devices. Please make sure that you're turning in any materials the day before, if you're scheduled to present the day before, by noon the day before. And I think with that, we're ready to begin. We do have, let me just see. We do have a work session. We have 5 bills on work session today, as well as 2 bills that we will hear. And so with that, we'll start with our work session. And I will have Ms. Thornton, our policy analyst, walk us through the first bill.
Thank you, Chair. Diane Thornton, Legislative Council Bureau for the record. Our first bill on work session today is Senate Bill 34, which revises provisions relating to legal representation in certain actions or proceedings, sponsored by the Senate Committee on Judiciary on behalf of the Attorney General and heard in committee on April 26. There are 2 proposed amendments. The first amendment, proposed by Leslie Nino-Pirro, General Counsel, Office of the Attorney General, proposed amending Section 1 to reinstate the language from the bill authorizing the Attorney General or the Chief Legal Officer or other authorized representative of political subdivision of this state to provide legal representation to a state legislator, and to amend Section 3 to reinstate certain language from the bill relating to special counsel employed by the Attorney General. The second amendment on the work session today is sponsored by John McCormick from the Administrative Office of the Courts. He proposed including judges of the Courts of Appeal in the definition of a state judicial officer. Thank you, Chair.
Thank you. Members, are there any questions? Not seeing any questions, I will take a motion to amend and do pass Senate Bill 34. Motion. I have a motion by Vice Chair Marzola. Do I have a second? Second. I have a second from Assemblywoman Newby. With that, are there any comments on the motion? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Nay. Okay, nays, raise your hand, please. So we have Assemblywoman Hanson, Assemblywoman Gallant, Assemblyman Urick, Assemblyman Gray, and Assemblywoman Hardy. Thank you for that. And with that, the motion passes, and I will go ahead and take the floor statement on that one. Next, Ms. Thornton, will you walk us through Senate Bill 37?
Senate Bill 37 authorizes governmental attorneys to volunteer as a third-party neutral mediators under certain circumstances, sponsored by the Senate Committee on Judiciary on behalf of the Attorney General, and heard in committee on April 26, and there's no amendments for this measure. Thank you, Chair.
Thank you. Members, any questions on Senate Bill 37? Not seeing any, I will take a motion to do pass Senate Bill 37. I have a motion by Vice Chair Marzola. Do I have a second? Second by Assemblywoman Mosca. Members, are there any further comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Okay, I will assign that floor statement to Assemblywoman Summers Armstrong. You're welcome. Next bill, Ms. Thornton, please.
Senate Bill 55 revises various provisions relating to courts, sponsored by the Senate Committee on Judiciary on behalf of the Nevada Supreme Court and heard in committee on April 21st. And there are no amendments to the measure. Thank you, Chair.
Thank you. Members, any questions? Not seeing any. I will entertain a motion to do pass Senate Bill 55. Motion. I have a motion by Vice Chair Marzola. Do I have a second? Second by Assemblywoman Summers Armstrong. Members, any additional comments? Not seeing any. All those in favor? Aye. Is anyone opposed? And with that, the motion passes. So I will assign that floor statement to Assemblywoman LaRue Hatch. You're welcome. Ms. Thornton, will you walk us through the next bill?
Senate Bill 62 revises provisions relating to the Commission on Judicial Discipline, sponsored by the Senate Committee on Judiciary on behalf of the Nevada Supreme Court, and heard in committee on April 21st, and there are no amendments to this measure.
Thank you, Ms. Thornton. Members, any questions? Not seeing any questions, I will entertain a motion to do pass Senate Bill 62. Motion to do pass. I have a motion by Vice Chair Marzola. Do we have a second? Let's do that one more time because we're tied. Do I have a second? Second. Okay, so I will go, okay, so with that, all those in favor, oh, no, I'm sorry. I have a second from Assemblywoman Newby. All those in favor, please say aye. Aye. Anyone opposed? Okay, I will go ahead and assign that floor statement to Assemblyman Urick. You're welcome. Ms. Thornton, will you walk us through the last bill?
Senate Bill 67 revises the definition of the term sexual offense for the purpose of certain provisions relating to parole, sponsored by the Senate Committee on Judiciary on behalf of the Department of Public Safety and heard in committee on April 25th. And there are no amendments to this measure.
Thank you, Ms. Thornton. Members, are there any questions? Not seeing any, I will entertain a motion to do pass Senate Bill 67. Yes. I have a motion by Vice Chair Marzola and a second by Assemblyman Gray. Are there any comments on the motion? Okay, all those in favor, please say aye. Aye. Anyone opposed? And with that, the motion passes, and I will assign the floor statement to Assemblyman Gray. Thank you, Ms. Thornton. That concludes our work session. Today we have two bills. The first one is Senate Bill 296, and it is sponsored and presented by Senator Harris and Mr. Josh Cole, who I believe is on Zoom. This measure revises provisions related to traffic stops. The hearing is officially open, so you may begin when you're ready.
All right. Good morning, Chair Miller and members of the Assembly Judiciary Committee. It is so good to be with you all today at 9 a.m. Love that start time. Thank you for that. My first time with you all this session, and there are many, many new faces, so happy to present a bill in front of this iteration of the Assembly Judiciary Committee. On the left, I have the esteemed, incomparable Miss Lisa Mosley, who will be also presenting this bill with me, and via Zoom, I have former Virginia Delegate Joshua Cole. Virginia has passed similar legislation, and so he will speak to their motivations and what their legislation looks like. I'll just briefly, if I may, Madam Chair, go over what the bill is, does, the mechanics, and then turn it over to Ms. Mosley and Mr. Cole for their comments. So a little bit of level setting here. This bill makes some traffic offenses secondary. And all that means is it can no longer be the primary or sole reason why a police officer pulls you over. In the state of Nevada today, we have a secondary seatbelt law. If you're not wearing your seatbelt and that's the only thing you're doing wrong, the cops can't pull you over. As a matter of fact, if you are talking on your cell phone and that's the only thing you're doing incorrect, the police cannot pull you over. If you are coming from out of town and you haven't registered your car within the 30 days we're supposed to say you're supposed to register it, the police can't pull you over. And so what I'd like this committee to do is just take a second and listen to the offenses I'm adding and think, is this any more dangerous than driving while talking on your phone or not wearing your seatbelt? I would submit that the answer is clearly no. And here in the state of Nevada, the reason why we have a secondary seatbelt law, despite the federal dollars that we're leaving on the table and all of the evidence that it actually makes folks safer, is because we believe here in this state that we should be left alone. If we aren't doing anything wrong, if we aren't causing any danger to anyone outside of us, we want to be able to move about our life. This bill reflects that just a little bit deeper. Okay, so the offenses. The first one is registration. And that really is now only down to 30 days. So if your registration is 30 days late or less, how about we let you just keep going? Now, that doesn't mean you're not going to have to pay your late fees when you go to register, right? You're not getting off the hook. You're still going to have to register your car. And if you are pulled over for something else, the officer can still cite you for that lack of registration. The next couple of offenses are related to your license plate and your moving permit. So if your license plate is just on the back and you don't have one on the front, but it's visible, we're going to let you keep rolling. We've got all these kind of weird ticky-tacky laws about how the license plate has to be securely fastened to the vehicle and a height not less than 12 inches from the ground. If you, for some reason, miss that, but it's still visible, we're going to let you keep rolling. And that's true also, again, of the moving permit. And then the last couple of violations are really related to mechanics. If you got one brake light out, just one, not two, you got one brake light out, you're missing one reflector or one tail lamp, we're going to let you keep rolling. Now, with these equipment violations, I wanted to ensure that we would allow officers to continue to provide their public service of letting you know you got a brake light out. Maybe you don't know. Maybe you don't know you got a tail light out. So I've authorized officers to continue to pull you over and give you a written or oral warning so that you know and you can go get that fixed. And I think that should mitigate some of the danger aspects that you might worry about here. That is the bill. That's it, from page 1 to page 6. I'm going to turn it over to Ms. Mosley for a couple of comments, and then to Delegate Cole, with your permission, Chair.
Good morning, Chair Miller, and good morning, committee. Happy Monday to you all. Monday is actually my favorite day of the week. People think I'm weird, but it is, in fact, my favorite day of the week. Why? Because we can use Monday to set the tone for how we want the rest of our week to go. So I've always loved Monday, and I encourage anyone who hates Monday to think about it from that perspective. I am excited to be co-presenting and offering supportive testimony for this bill this morning, along with Senator Harris. It is something that the Fines and Fees Justice Center is passionate about. I am Lisa Mosley. I am the Nevada State Director for the Fines and Fees Justice Center. And for anyone on the committee that does not know, the Fines and Fees Justice Center is a national organization that works to eliminate fees in the criminal legal system and to work to ensure that fines are proportionate and just and proportionate to an individual's ability to pay. One of the reasons we're supportive of this bill is because, as I mentioned earlier, it is something that the Fines and Fees Justice Center wants to expand our work with, and we're passionate about this issue. And one of the reasons is traffic stops are the most common reason for contact with law enforcement in the United States. There is research that shows that these traffic stops are not always for moving violations. Instead, they are for what is often considered, as Senator Harris pointed out, administrative infractions that are unrelated to a motorist's driving, behind the wheel driving. These fractions include some of the things that Senator Harris said: a broken taillight, a taillight that's not illuminated, a license plate that's not secured in the position it should be, or something like that, a vehicle registration that's a few days behind. In 2020, a UNLV study conducted a study that found that 58.6% of traffic violations that had turned into warrants were for administrative violations. They were not for behind the wheel driving. They were not for infractions that were directly related to public safety. Only 16% of those infractions had turned into warrants, were actually related to a motorist driving. Based on nationwide research and data, we all know and we are aware that these traffic stops mostly impact low-income communities, communities of colors. We all know that. But there is an aspect of these traffic stops that is a lot less often talked about, and as is the significant risk that it poses to law enforcement officers. According to a Department of Justice study in 2017, the most common activity, police activity that led to police deaths were the common traffic stop. I will send that report to the committee if you would like. It's an issue that needs to be addressed, and there are a handful of places across the country that are actually addressing this. Philadelphia is, Pittsburgh, San Francisco, and the entire state of Virginia. And hopefully we get to add Nevada to the list of those jurisdictions who are prioritizing our community safety and our officer safety and making these offenses secondary. We believe that in doing so, this will free up officers on the street to work on crimes that do directly impact public safety and crimes that we would consider more serious. So with that, those are my comments in support of this bill. I will stand with Senator Harris once our next presenter presents and be ready for any questions that the committee may have. Thank you.
And Madam Chair, if I may, I'll just invite Mr. Cole to turn his camera on and begin his presentation if we do in fact have him via Zoom. Mr. Cole, whenever you are ready, sir.
Good morning for you all. I'm here. I'm having some technical difficulties with my camera. So just give me a few moments as I get my camera on. But thank you to the chair and members of the committee for allowing me to join you all virtually today. I do want to speak in support of this bill. We passed a similar version of this bill back in 2020 during our special session in the General Assembly here in Virginia. And I echo the comments of the senator that as we look at this bill, it's for safety of both our law enforcement and the citizens in the community. We also, as I mentioned when I spoke before the committee a couple of weeks ago, I talked about how we had a community policing act that we passed as well. And during that Community Policing Act in Virginia, when we took a look at the data that was presented back to us, we found out that 30% of traffic stops were counted against Black Virginians, even though they only represented 19% of the state's population. Also for Latinx drivers, they accounted for 9% of stops, even though, I take that back. They are 9% of the population here in Virginia and counted for roughly 55% of the stops as well. And so as we're taking a consideration of this bill, we're looking at community safety, public safety. We want to make sure that our law enforcement agents are protected. We wanted to make sure that our communities were protected. And so that was one of the reasons why we passed this bill. Very much similar with the situations where it's the registration, the tags being expired, the headlight being out. We utilize all of those in our bill as well. And unfortunately, I don't have the data as of now how that has changed. I'm unfortunately not in the legislature anymore, but I could get that data if anyone would request it as of today, since that bill has been in effect in Virginia for going on 2 years now. But I can certainly get that data if anyone would like. But I urge you all to support this bill as it's been in effect in Virginia for over 2 years. And we have seen that this has both protected our law enforcement agents and our community members as well. Thank you.
Thank you so much, Mr. Cole. We appreciate your perspective, and although we can't see you, you've got that lovely standby photo, so that did you just fine. Thank you, sir. With that, Chair Miller, we will stand for any questions the committee may have.
Thank you. Our first question is from Assemblywoman LaRue Hatch.
Thank you, Chair. Thank you for being with us this morning. So my question is, if a peace officer does pull someone over, if this is in effect, they pull someone over for one of these offenses, what are the repercussions, I think, both for the officer, but also what is the legal recourse for the individual that goes through that?
Thank you for the question, Assemblywoman LaRue Hatch, to you through Chair Miller. Dallas Harris for the record. It would be the same remedies that are in place when an officer makes a stop in violation of the law today. So it doesn't change the remedies available, and often those are very sensitive to the facts. And so, you'd have to challenge it, you'd have to challenge the stop, and then a court would deal with that accordingly.
So I'm sorry, what are those remedies?
Thank you for the question, Chair Miller. So I do not practice in this area of law. I do know that there are times where if an officer was not supposed to stop you or didn't have probable cause for the stop in the first place, that evidence that they may have found could be tossed out depending upon the arguments that the lawyers use. But that is not always the case. Again, it really depends on the circumstances, and I would be getting out of my depths if I was to mention other remedies that might be available.
Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. So just last week, just over the weekend, I got the notice from DMV saying that my registration is going to be due soon. And with that and reading the bill, it made me think about a situation where there have been times when I had the renewal sticker in my car and I just wanted to clean off my license plate first, but I was late to work, and then 3 weeks later, it's still in my car. And obviously, Metro Highway Patrol, they're different agencies than DMV, but has there been any thought about possibly if an officer sees something like if this passes and an officer sees that someone doesn't have their registration up to date, like sending out notices, something like that, or is it just presumed that'll just be done through DMV, and whatever happens, as you said, they'll accrue the fines and they'll have to move forward in that way?
Thank you for the question, Assemblywoman Cohen. To you through Chair Miller, Dallas Harris for the record. So officers would not be sending out notifications, as they don't do that currently. It would remain through the DMV. I know we have some law enforcement agents in the audience, and as they come up to testify, they may be able to speak to their ability to electronically check whether registration is up to date regardless of what's on the sticker. It's my understanding that most patrol vehicles, but maybe not all folks on patrol, have the ability to kind of double check that it is in fact registered, even if your sticker didn't quite make it onto the vehicle. But there would be no additional law enforcement notification requirements through this particular piece of legislation.
Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair. Good morning. Good to see you both. I just had a question regarding, so we think about, and I don't know where these stats would be. I know you might not have them, but if law enforcement did, and it's really just a curiosity I have. So we know that sometimes really dangerous people have been caught over a traffic stop. It's almost like they hit the jackpot because they got this guy who's been on the run or a gal that's been on the run. So in this instance, I'm curious how many times we've caught somebody like that based on some of these very minor things. And I get what you're trying to do, and I support that. I was just curious on page 6, on section 9.9, under number 7, is that the kind of the leeway that we have then, that the officer could stop and give the oral warning, and then maybe he's run the plate or she's run the plate? Do you get what I'm getting at?
Yes, thank you so much for the question, Assemblywoman Hanson, to you through Chair Miller. Dallas Harris for the record. So Section 9.9, subsection 7 really is about allowing the officer to give you that notification. Hey, you're let's see, this section is, this is stop lamps, this particular section. This is the one that allows an officer to give you a warning that your stop lamp is out. And, you know, I think you are in fact correct. Officers have conducted small stops and found big things. My response to that has generally been, we could also allow officers to go and knock on every door and hope that some criminal is in fact behind it, right? But the basis of our system is that we only allow officers to go looking when they've got probable cause for it, right? And so yes, if we all actually kind of relaxed our rights a little bit, cops might be able to find more folks. But that would generally require them to be able to search without any other reason to do so. And that makes me a little uncomfortable when officers are pulling you over for something small, but they're hoping that they can buy the time to find something big, right? It is a trade-off, right, that we do in fact face. But my little conservative heart says that a police officer has to have probable cause for what they stopped you for. And if they don't have probable cause for thinking you committed some horrendous murder, then I should be able to keep on driving.
A follow-up, Chair?
Yes, please.
Thank you. Exactly, and I'm on board with you on that. I don't want this to be used as an ability to just find other stuff. I totally get that. But I'm thinking that the way the presentation came across is an officer, on the tail lamp, they can pull you over. But for the registration, no, if it's within 30 days, correct? Did I understand it right?
Yes, thank you for the question, Assemblywoman Hanson, to you through Chair Miller. Dallas Harris for the record. Yes, I specifically added the ability for the warning for the equipment violations so that we can allow officers to remind you, hey, did you know your tail lamp's out? You know, because folks may not know, and maybe it takes that officer to give you that warning for you to even know that you had some failing equipment, right? When we're driving in our cars, we can't really necessarily see our brake lights or know if they're out. And so I wanted to maintain that ability with respect to those particular violations.
Perfect. Thank you for that. Appreciate it.
Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. Thank you, Senator, for bringing this bill. My question really is more on the larger policy schematic for Nevada. The governmental services tax, which is part of your car registration, is a large part of what funds our state, unfortunately. I would rather it not be, but being Nevada, that's the way we've set things up. And so my question is, if there's no penalty, if I drive fine and I never make any mistakes and I never speed, but I never register my car, how is that ever fixed? Like, how do I ever pay up?
Thank you for that question, Assemblywoman Newby, to you through Chair Miller. Dallas Harris for the record. So this would not allow you to drive your vehicle if it's just completely not registered. You need a license plate on the vehicle. There's nothing that would allow someone to just kind of roll around in perpetuity without any registration or having a license plate or a moving permit on your vehicle. When it comes to the moving permit specifically as well, as so when you first buy a car, that's what you're going to get. This bill does not touch the provisions that require the moving permit to be valid. And so if your moving permit gets expired, we're going to pull you over. The second thing I'll note is that it's just 30 days, so the second you roll into month 2, you're going to get pulled over. The third thing I would say is that if you even go 5 miles, if you're going 2 miles over, right, the speeding is no longer in this bill. There was a version that would have speeding as a secondary violation from 0 to 5 miles an hour. That's no longer in this bill. So if you're going 2 miles an hour over, an officer can now cite you for your registration as well. So if you get pulled over for something else and you have any of these violations, the officer can cite you for all of them. So I'm not as, I don't think there's a scenario in which someone can in perpetuity not have their vehicle registered for a long period of time and kind of skate our laws.
Did that end? Yes, please, Assemblywoman.
Thank you. Second question, and I promise it's the last. What if you have 2 or more secondary violations? So I'm not wearing my seatbelt, can't pull me over for that. My car registration is expired, can't pull me over for that. And my taillight's out. And you can't pull me over for that either. But I got all 3.
Thank you for the question, Assemblywoman Newby. To you through Chair Miller, Dallas Harris for the record. So with the tail light, they would be able to pull you over and give you a warning for that one. And so you're gonna get some lights, right? Potentially there. When it comes to multiple secondary violations, I do not believe that the way the law is constructed, you would that leads to necessarily one primary. Right? So if each one's a secondary, then each one's a secondary. And you don't stack up several secondaries to then make probable cause to pull someone over. But I'll tell you what, I don't know any person who doesn't go 5 miles over every day. And so officers will still have plenty of mechanisms, I think, to pull folks over who they feel are actually dangerous on the road, right? If you are causing some danger, which for most of y'all who live in the South know we've got a really bad DUI problem, right? If you're out on the roads past midnight, you're going to see likely someone who is visibly drunk driving on the road. This will allow officers a bit more time to focus on those dangerous drivers that we need to get off of the streets and not worry so much about those people who were driving 10 and 2 but may have a small mechanical violation or were just slightly late on their registration. And then I'll also note just briefly, nothing changes about the fees. So when you go and you need to go register that vehicle, the later you are, the more expensive it's going to cost you, and that penalty and check will continue to be there.
Assemblywoman Bilbray Axelrod.
Thank you. I'm just curious. I'm trying to make sense of the idea that you could get pulled over and get a warning. So the officer is still pulling you over. So how is that keeping officers safe if that's...
Thank you for the question, Assemblywoman Bilberry Axelrod. To you through Chair Miller, Dallas Harris for the record. So my goal originally, if you would have saw the first iteration of this bill, there were probably about 10 offenses on here, right? And as the legislative process often goes, I've had discussions with the law enforcement community, with progressive partners, and this is the compromise that we have come to. In order to try and walk a line of both safety for officers and for folks who are on the road. Ideally, I'll admit, I maybe wouldn't have had them be able to even pull you over for those small things, but I can admit that I was persuaded that there may be some function in allowing them to continue to give a warning so that folks will know when those equipment violations are actually occurring. Otherwise, you got to wait for your husband to see you pulling out the front lawn or something to let you know, oh, hey, the taillight's out. And so it's a balance that we've been trying to strike, and I think that this piece of legislation will significantly reduce police and civilian interactions when not necessary. And then when they pull you over for that warning, I think that, and I hope that as long as it is a warning, often oral, hopefully not written, but they can give the written one, that the interaction is very short and is designed not to extend beyond as long as traffic stops are supposed to extend within our constitutional laws.
So I guess I have a question about that. While you're saying you're trying to protect the officers, and you refer to them as people in vehicles, but, Nevadans, Americans. So can you explain a little more what you're trying to protect them from?
Thank you for the question, Chair Miller, to you, through you, Dallas Harris, for the record. Yes, so as Ms. Mosley mentioned, traffic stops are dangerous for both civilians, Nevadans, as well as police officers. And it's often because they can be scary, right? Anytime a police officer pulls someone over, because this is the United States of America, that person may have a gun in their vehicle. And officers are very much prepared for that scenario. Officers know that traffic stops can be dangerous. And on the flip side, there are populations of Nevadans and Americans who are just as scared of police interactions. And so sometimes this turns into a scenario with which people are being pulled over because they fell asleep in their car and now they're running, and things get jumbled, and officers are caught in situations where they are afraid, the person who got stopped is afraid. And I've seen this scenario even when it comes to jaywalking. I did a ride along, and there was an officer who stopped someone for jaywalking, and he ran, and then they got into a scuffle, and then it turned out the guy had a gun, and now the officer's in a life-threatening situation. And so I think if you've watched the news anytime in the last 5-10 years, you're familiar with police interactions gone wrong, based on often small stops like taillights. I believe that was the case in a South Carolina case where a young man was shot while he was running away. And so the goal here really is to try and minimize those interactions when not necessary for public safety, in order to keep both our law enforcement officers and the community safer.
Senator, can you clarify what you mean by gone wrong? When you talk about a man running and getting shot and people being scared, did that person have a weapon? What was the officer scared of?
Yeah, thank you for that question, Chair Miller, to you, through you, Dallas Harris, for the record. So I can't even remember the name of the gentleman in this particular case, and often it's because there are too many to remember. But there was a gentleman who was pulled over, and I think maybe he might have had a warrant, and so he kind of took off. And there are mixed stories about whether he had a weapon. There was some evidence that maybe an officer kind of plopped a weapon near him after. Not that that is generally the case when these things happen, but these are and can sometimes be life and death situations when they don't have to be. The committee may be familiar with the story of Philando Castile, who is a young man who was stopped by a police officer, told the police officer that he had a gun because he was trying to come clean and let the officer know that there was a gun in the vehicle. And then at the end of that interaction, Mr. Castile was dead before he didn't even get out of his car. So there are many examples where police officers feel like their life is in danger. Sometimes their life actually is, and then we see citizens being shot. Did that answer your question, Chair?
Not specifically.
Chair Miller, if I may.
Please.
Lisa Mosley, for the record. I'd just like to offer some additional commentary and some data also that may help shed some light on some of this. We were talking about officer safety and also community safety, and I want to just point out that officers always have discretion. We never want to take that away from officers to be able to pull someone over if they feel like they need to. That's always going to be there. But I just want to point out a couple of studies that we have some data on. A 2012 study, I believe it was. That's the most recent numbers that we have for this. A New York study. Almost 300,000 frisk, stop and frisk. Officers initiated traffic stops and frisk. almost 300,000, only 2% of those yielded weapons. 2%, it's a very small number. Study out of, I believe it's Washington, D.C., 63,000 stops. Only 1% of those stops yielded any kind of weaponry. So from that perspective, we're putting officers in danger, we're putting community members in danger when it's not absolutely necessary. I just pointed out a study that was conducted by the University of Nevada, Las Vegas. It is a study that was conducted in Las Vegas. This is Las Vegas data. It's not out of another state. It is our own data. That when I said 68.7, I don't remember what I quoted. I'll look. Almost 70% of traffic stops that were conducted by Las Vegas Metropolitan Police Department members that were cited, were for violations that were not related to dangerous driving. They were not related to public safety. They were for violations. Matter of fact, the one that the highest percentage of was pulled over for was vehicle registration. People just simply didn't have the money to register their vehicle. They had a taillight that was out, that was broken or not working, and they didn't know it, or maybe they did know it and didn't have time to go to the auto parts store and get a bulb and get it replaced. These are the things that we're asking you to think about. We're not taking away the ability for officers to do their job. As a matter of fact, we're trying to make it safer. Officers will always have discretion, but if they see something that they feel like they should pull someone over for, there's a way. I think this bill gives them a way to do that. But if it's something that's not absolutely necessary, if someone is driving and their vehicle registration is simply expired, officers do have the ability to run that plate to see if there are any warrants, if there's anything that we should be thinking about pulling this person over for. They will always have that. But if it's simply a vehicle registration that's a few days, let them go. It's not necessary to endanger people's lives because someone has a taillight that's out, a vehicle registration that's expired, or a license plate that isn't secured where it should be. And again, officers will always have discretion to be able to do that. So I just wanted to point that out because we do have some numbers. So if I can stand for questions if there are any questions related to that.
Thank you for that. One, I'm shocked that the most recent study was 2012.
Lisa Mosley, that's the one that the most up-to-date data that we have. We have
Correct.
been able to access.
Okay, thank you for that. Because the trend in the past decade I would be very interested in seeing those numbers. But in these few studies that you did mention, when you talk about safety, who was more at risk? Was it the people or the police? Which side did these interactions actually result in harm for?
Lisa Mosley, so let me make sure I'm understanding what you're asking me. Are you asking me who was most harmed?
Or victimized, yes.
Victimized. Chair Miller, I really like to refrain from using the word victimized.
Okay.
What I'm saying is this presents danger for both sides. The study that I cited, this is a Department of Justice study that was done in 2017. The study was specifically on officer deaths. And within that study, the most common reason for officers that was the officer-initiated traffic stop. Now that encompasses all stops. But my point is if we can minimize those stops through something as simple as not pulling people over for a broken taillight or a vehicle registration that's expired, then let's do that. It's dangerous enough, and I speak to you as a former officer. I rarely talk about my law enforcement career, rarely, because it's just not something that I talk about. But I speak to you from that perspective. It's dangerous enough being on the street, pulling people over, people looking in their mirror and they saying, officers, oh my God, I don't know what's gonna happen. But also officers walking up to a car and having no idea what they're facing. That's common. And so let's do that only when they have to, not when they don't have to.
It's interesting that we live in a city where if you extend your time for your parking meter, you would get mailed a parking ticket. And yet, why isn't the same for if it's just simply registration or plates or taillights? Why isn't it simply you just get mailed, hey, here's your warning?
Lisa Mosley, in an ideal world, if Fines and Fees Justice Center has our way, that is the way we're going. We have absolutely talked with some jurisdictions about that. As a matter of fact, we had worked recently with the city of Reno to implement what we call a lights on program. We're working with them to do a pilot program. If someone has a tail light that's out or broken, and an officer will pull them over, and rather than giving them a citation, they give them a voucher to say, this is where you can go and get your tail light fixed. This is where you can go and get your headlight fixed. Imagine what kind of relationship building that would be for community members if an officer pulls them over, and instead of giving them a citation, they give them a voucher to say, this is where you can go get that fixed. Like I said, if the Fines and Fees Justice Center has our way, that's where we're headed. We would love it if people got a citation in the mail. That would eliminate all of this, but it would still hold people accountable. So, and we want people to be held accountable, but we also want to keep everyone safe as much as we possibly can.
Thank you. We still have a few more questions. Our next question is from Assemblyman Urick.
Thank you, Chair. Senator, it's nice to see you in this context and off the basketball court. You're much less intimidating in this hearing room. First, I also want to commend you and say thank you for your work with, in the other house, to work with the stakeholders and to listen. That is, it's a testament to you as a legislator that's willing to craft legislation, listen, take the feedback, and what we have is a lot more palatable today, I think, at least from my perspective. It's interesting because the broader policy that we're talking about here, right, is I don't think fully addressed in the bill. I think that there's some elements of this, but there's a broader context for a conversation about how proactive we want our law enforcement officers to be. And it is certainly a dangerous job. As somebody that's done thousands of stops, I think just the high volume that you do and you walk up, you think you're just approaching somebody about a brake light and they just robbed a bank. It's difficult to maintain that heightened level of awareness and situational awareness. So that's why they're dangerous. So I appreciate what you're trying to do here. But like I said, I don't think that is fully resolved in this bill. And I want to clarify that if I can through this question. With respect to the ability for an officer to, and by the way, let me also just say, the other term for this is a pretextual stop, right? Well, I use something like a registration or broken light as a pretext for a deeper investigation that I would like to do. I don't think, and I want to confirm, which by the way, that is legal under the Wren decision, Wren versus U.S., I think it goes back to 1996, clarified as completely constitutional pretextual stops. So if an officer in this scenario under your bill, assuming it passes and became law, decides to pull an individual over and warn them that their reflector is out, and if that officer approaches the car and sees that the driver is exhibiting symptoms of maybe being under the influence, would that officer be permitted to continue that investigation, or there's an open container and actually now still investigate a secondary offense, even though the intent was only to originally walk up and offer either a verbal or written warning? So can you clarify that sort of investigation and therefore a pretextual stop would still be permitted under this law?
Thank you for the question, Assemblyman Urick. To you through Chair Miller, Dallas Harris for the record. So I would suggest what you described is actually not a pretextual stop. That is a stop where you had no probable cause for a DUI, but then as you approached, the driver was exhibiting signs, and so that probable cause or reasonable suspicion was developed throughout the course of the stop. And that would continue to be allowed under this legislation if passed. Now, what would be pretextual, I believe, is if a bank had just been robbed and we had no idea what the car looked like or what the suspect looked like, and the officer sees someone drive by and go, oh, that guy looks funny, and his taillight's out. So I'm going to pull him over and then start investigating to find out if he's the bank robber, right? So I would put a small difference between those two scenarios. And any time when an officer does a stop, an additional probable cause or reasonable suspicion arises, right, that then allows for the additional investigation under current law, and all of that would continue. And Assemblyman, I do think you are correct. This does not eliminate pretextual stops. that is a much broader piece of legislation. But I'm hoping that this bill strikes what is a balance between constitutional law, which does, as you are correct, does allow pretextual stops, and what is, I think, a quintessential Nevadan belief that we should be left to our own devices unless we are causing some type of harm.
Yes, please.
Thank you for clarifying, because that example probably wasn't the best example of a pretextual stop. So let me pose maybe a different scenario. So let's say an officer decides he's going to pull an individual over, and I'm just going to assume that this is pretextual, right? Broken taillight. And approaches the driver. Would the officer be permitted to, for example, run that driver, run them through NCIC, local crime database, and find out, for example, that this individual has a recent history or an arrest for possession of a controlled substance? Would the officer then be able to, under this stop, where the initial intent was only to issue a warning, would that officer be able to then engage in further conversation and perhaps talk to the individual, perhaps ask for consent to search the vehicle if there were is some illegal contraband in the car? So that might be a better, more accurate pretextual context stop. Can you clarify, under your bill, would that officer be permitted to still do that?
Thank you for the question, Assemblyman Urick. To you through Chair Miller, Dallas Harris, for the record. This bill does not change anything about consent stops, or consent searches. And the kind of constitutional law, and that is very broad. And so officers would still be able to allow for consent searches within the confines of existing law, right? So there are some guardrails around how long a stop can last. It's not supposed to be any longer than the purpose that they stopped you for, unless really that additional reasonable suspicion or probable cause arises. And so, I would suggest if you pull me over for my tail light and you've got me there for 30 minutes, you might run into a problem, right, with just the state of the current law. And so this bill doesn't change any of that. And the stops would have to be within those reasonable limits that the Constitution provides us. Does that answer your question, sir?
Yes, it does. Thank you, Chair.
You're welcome. I'm going to save my follow-up to your question, Assemblyman, for the end. Let's go to Assemblywoman Summers Armstrong.
Thank you, Madam Chair. Thank you, Senator, for the presentation. It's good to see you as well as Ms. Mosley. So during the last session, when we were in COVID, I'm pretty sure that we learned that the police have the ability, when they see a tag that is expired, to run it. And can you clarify for me whether or not during that they can, is that running the tag only for registration, or does it bring up any other records, as was alluded to by my colleague?
Thank you for the question, Assemblywoman. To you through Chair Miller, Dallas Harris, for the record. I would have to leave that to the law enforcement officers in the room who are going to come up and testify. I've never actually had to run a vehicle, and so I'm not sure what information they get back, or if they have the ability to just run registration or just run insurance, or if they run a license and it gives you all the information at once. I'm not familiar with those mechanics, although I can confirm that officers do have the ability to check to see if registration is up to date. The sticker's not the only piece of information that they have available to them. But again, I think it may not be available in all instances. But again, I'd have to have law enforcement confirm.
Madam Chair, follow-up, please.
Yes, proceed.
Thank you. Could we ask, Madam Chair, because I'm very curious about this. I thought that this was, this information was readily available to police when they ran tags. And I'm curious about this.
Let's,
Thank you.
not yet, no, not yet.
Okay. And I'm curious about this because, as you know, everybody knows, I live adjacent to the west side. I drive an old car, and my headlight often goes out because I drive an old car. And one of the things that we saw during the last session was that we were talking then about jaywalking because it was a misdemeanor. And at the time, there was something like 8,000 outstanding jaywalking tickets that were pending in justice court during the 2021 session. And the data showed us that most of those jaywalking tickets had been given in my area and to the east. And that even during COVID, and just bear with me, people were being pulled over for registration even when the DMV was closed. And so I think that we need to be honest about what we're trying to do here. Maybe the senator wants to be, PC about it, but I'm just going to tell you what I know. And that is black people and brown people get pulled over for this stuff more than anybody else. And we're the ones that are in danger. Police are taught that we're dangerous in a traffic stop and often come to the situation with heightened response, and it's dangerous for us. And so if the police could answer the question, that would be great. But do you have any of that breakdown data, Ms. Mosley, racial data, or even geographic data for the stops? That would be great.
Lisa Mosley, Assemblywoman Armstrong, to you through Chair Miller. If you could repeat your question specifically, are you asking about the number of jaywalking tickets?
So I think I was okay with the jaywalking, the registration tickets. If you have any data that you can break down, either a location as well as a race, would be wonderful.
Lisa Mosley, for the record, no worries. I actually do have that data. I just have to search for it. So give me just a second. I have the study open. I just have to find the page that it's on.
And Chair Miller, if I may, I'll just note that in the last legislative session, I passed legislation that will set up a statewide comprehensive traffic stop database. And so we will very shortly here have detailed, up-to-date numbers about traffic stops in Nevada, where they're happening, who they're happening to, what different types of stops are occurring. And that is something that our Department of Public Safety is working with all law enforcement agencies on standing up right now. And so even though some of our data is a little older than we'd like, know that fresh data is on its way as soon as we get that dashboard set up.
And I think I'd like to re-articulate what the Assemblywoman was asking in her original question. I believe that she was asking that if an officer goes in to look at the registration tabs and there's other information in there, can they use it? Now, I'm assuming the question is yes, because how else would they find out there's a warrant for this person? So could you speak back to the Assemblywoman's original question?
Absolutely, Chair Miller. To Assemblywoman Summers Armstrong, through you, Chair. Dallas Harris, for the record, yes, law enforcement would be able to use any information that that comes available to them through any, databases that they have available. Currently, today, a law enforcement officer could run your plates just because he's sitting right behind you, and so you actually didn't have to go 5 over or have an expired registration or anything like that. They are in fact free to just run your plates as you roll on by. So that would still remain the case after this legislation was passed.
Assemblywoman, did you have any follow-up questions to that?
I'll just wait for the data if that's all right, Madam Chair, and the answer from the police if that's okay when you deem that's appropriate to receive that. Thank you.
Okay, thank you. We're going to go ahead and, while Ms. Mosley is still looking up those answers, we're going to go to Assemblywoman LaRue Hatch.
Thank you, Chair. I just wanted to follow up on my first question. We talked about the possible remedies for the individual that was cited, but I don't think we talked about the repercussions for the law enforcement officer. And I know we had a very long discussion on Friday about not criminalizing officers for doing their jobs. I also know, though, if a penalty is not specified in NRS, it is a misdemeanor. And so I just wanted to make sure, does this mean that our officers would be charged with a misdemeanor if they cite someone, or is there some other penalty?
Thank you for the question, Assemblywoman LaRue Hatch. To you through Chair Miller, Dallas Harris for the record. No, there would be no criminal penalty for law enforcement if they conducted a stop and then improperly conducted a search after that stop. The remedies for issues like this, as we were discussing, is often in case law and would have to be handled in the court. The best thing that could happen for a defendant is that all evidence that was found by virtue of a stop that was not supposed to occur in the first place would be thrown out, and we'd have to start at ground zero. But no, there would not be a misdemeanor for law enforcement officers if they pulled you over and they weren't supposed to.
Chair Miller, if we're ready, I believe I have some of the data that Assemblywoman Armstrong is asking for, but I will wait for your cue.
I just first wanted to make sure that answer was sufficient for the Assemblywoman. Do you need a follow-up?
But that's not, just maybe from our legal.
Okay.
No, it's not a crime.
Okay, thanks. Yeah, my concern with that is, though, by the time we get to the court process, the individual's already been, their rights have already been invaded, the person's already been traumatized, and so, yeah, that's a long way down the road for a remedy.
Yes, thank you for that, Chair Miller. To you, through you, Dallas Harris for the record. I would agree with you that that is a really long time before you've already been arrested and your rights have in fact been violated. I, however, am unfamiliar of any time where we criminalize an officer for violating civil rights unless there is a kind of willful and wanton beating, right? Then we say, okay, that's outside of the scope of the job, and now you're just assaulting someone. And assault is a crime, and so we're going to charge the officer with assault. Aggressively or even inadvertently or slightly violating your Fourth Amendment right, we've generally not treated as something that we allow criminal penalties for on the law enforcement side, and I think that would be a bit of a departure from our general scheme.
Yes, and I don't believe anyone's suggesting to criminalize the act. We just want it to stop.
Thank you for that, Chair Miller. To you, through you, Dallas Harris for the record. Absolutely. I agree, and I think that in my discussions with the law enforcement stakeholders in this building, I have made myself very clear about what the intent of this legislation is. And at this point, it will be, if this bill was to pass, incumbent upon all law enforcement agencies to sufficiently train their law enforcement officers on what the state of the law is, and to make sure that that is in every manual and that every officer is up to date with the law. Because otherwise they do in fact risk catching those big guys because they weren't supposed to stop you in the first place. And so I know that there will be training on this, and I've also had some further discussions, although I didn't put this in the legislation, around when it's proper to be asking for consent stops if you're just stopping someone for a tail light out, right? We're going to try and limit those as much as possible. But I do agree with you that we pass the bill, we say we want you to stop doing it. That's what we want you to do.
Ms. Mosley?
Lisa Mosley, Assemblywoman Armstrong, I believe you're asking for zip code data. So the top 5 zip codes, and based on the 2020 study, where the most open warrants, and again, these are all warrants, but the majority of these would be for administrative offenses. The top one would be 89108, where 8.9% of warrants come out of that zip code. The second one would be 89101, 7.2%. The third one would be 89101. That's 5.6%. Next would be 89030 with 5.2%. 89106 is following with 5.2%. And I will submit this study to the committee so that you all have this study to refer to. There are additional zip codes, but those are the top 5.
Follow-up, Assemblywoman?
Thank you, Ms. Mosley, for your always data-driven. I will just say for the record that 2 of those are in my district, and 2 of them are immediately adjacent to my district. So as I said before, these types of stops for these things like mechanical and registration put poor or working class, Black and brown people at higher risk, which is backed up by the data. Thank you.
Lisa Mosley again. To your point, Assemblywoman Armstrong, Chair Miller through you, to your point, I do have median income data for these zip codes as well. And the highest one, 89108, that had the most warrants, the median income is $46,165. I'll go down to 89106, which was the 5th highest. The median income there is $29,906. So there is definitely a correlation between income and ability to pay, which we know from previous sessions resulted in people getting traffic warrants. And thankfully, this body passed Assembly Bill 116 that made those civil infractions versus criminal infractions. So thank you.
Thank you for that. Our next question is from Assemblywoman Gallant.
Thank you, Chair. Hi, good morning. Thank you for presenting this bill. And I appreciate the intent of what you guys are trying to do. Somebody's been pulled over for her registration because I just forgot. So I am curious, as it was presented in terms of the fact that it is reducing the danger for both parties, the officer and the citizen that is being pulled over, because many times it ends up in escalating events. But they still have the ability to pull over for warnings. And I'm curious how that's going to reduce these escalating events, because most likely the person being pulled over is not going to know the intent of the officer that it's a warning. So if they have something on them that's illegal or that they're scared of, they may run, most likely, right? Whether it's going to be a ticket or a warning. And so how is the ability for them to just issue a warning and it not be a ticket actually going to reduce the consequences for both parties? Also considering the fact that there seems to be some tensions in terms of possibly the ethnicity of the person that's being pulled over, as being presented earlier. So can you help me understand how that's going to help reduce that?
Thank you for the question, Assemblywoman Gallant. To you through Chair Miller, Dallas Harris, for the record. If you're telling me you'll vote for this bill if I take out the warning provisions, that's an amendment I'll put forward.
I don't think that was what I was inferring. I was just curious about how this was going to result in less dangerous, in situations and in situation, like with just it being the warning, because the person being pulled over does not know what the intent of the officer is.
And this is similar to the question that Assemblywoman Hanson answered, and I'll just say it's not. Obviously, we would have less police interactions if I removed the warning provisions. And so it doesn't get us all the way down to 0, right, for each of these infractions. It is a step, I believe, in the right direction to, to minimizing these interactions. It will not eliminate them completely. And I'll just note again, the warning provisions are really for the mechanical aspects, not for the other violations that are in here, like the license plate and the registration. And that is, again, so that law enforcement officers can continue to let people know, hey, your light's out. I was persuaded that it is, in fact, difficult to know if you've got a reflector out or a taillight lamp out if an officer doesn't, let you know or give you a warning. And so I was willing to add that into these mechanical offenses. So I started all the way over here, right? And then the bill has moved a little bit more in one direction in what I think will strike a balance between not letting officers pull you over ever for anything, right? And putting a thing of list on where officers shouldn't be pulling you over. It's not probable cause. But then, you know, when it comes to some of this mechanical stuff, if they want to give you a warning, they can. So it's a balance I've tried to strike. And I'll turn it over to Ms. Mosley. I believe she also has some thoughts on this.
Lisa Mosley, I just wanted to point out, it's just additional options for officers, which I believe they asked for. Officers will always they have discretion whether they want to pull someone over or not. It's just an additional option. That's all it is. And hopefully, again, as Senator Harris has said, it is it's a step in the right direction. It just gives officers additional options.
How about I'll follow up to this, Assemblywoman? Or you can follow up, and then I will.
Sorry, I'm just trying to draw a straight line to officers can still pull over and just give a warning, and that's going to reduce these interactions, provided the fact that the person being pulled over is not going to know the intent of the officer. I'm just trying to create, because I know you guys are talking about these studies and looking at New York, San Francisco, you said Pittsburgh, I believe, and then also Virginia, and wondering how this has actually reduced the amount of violent interactions between the police and private citizens. Because I know we're all watching that crime is rising at an exorbitant rate in San Francisco and New York in particular. I mean, so much so the National Guard's been called into San Francisco to deal with some of their crime issues. So again, I'm trying to find how is this going to reduce and increase safety for the officers and the citizens in a situation like this when they can still pull over.
Thank you for the follow-up, Assemblywoman Gallant, to you through Chair Miller, Dallas Harris, for the record. I again want to separate the license plate, registration, moving permit portions of the bill from the mechanical portions of the bill. Okay, so for those first three, we will not be allowed, there are no warnings, right? There's no oral warning or written warning. Now, for the mechanical ones, specifically those, I have chosen to allow officers to continue to give a written or oral warning. I personally, in my experience, I've been pulled over one time and I was speeding kind of fast on the 215, and the officer comes up to my window, right? And I go and get my ID, and he goes, "Oh no, that's not going to be necessary. Just slow down," right? And so, I mean, I almost knew right immediately. He didn't even ask me for my registration and my license plate. He was just there. He wanted to give me a warning to tell me to slow down. That is just one iteration, I think, of what it can look like when an officer is just there to give you the warning and to let you know, hey, your tail light's out. I just wanted to let you know, right? Again, I don't think that this is going to get interactions to zero, right? But it will ideally severely limit those interactions where officers do not need to put themselves at risk, the public doesn't need to be at risk, and there's no return on that risk for the public or for officer safety.
So I think what I hear, the general consensus is that we're agreeing on the goal to reduce traffic stops. However, we're not sure that with this bill we get there. And when we say officers can give warnings, again, and it's to their discretion, then if I were to have my officers report back to me at the end of the month, how many traffic stops did you do and how many were just based on giving warnings or your discretion, I as an officer can just report back, oh, well, my discretion told me I should stop them all. right? Yes, we've all, I shouldn't say we all, but many of us have experienced officers just pulling us over just to give us a warning. Or we talk to them and they're, okay, we'll just write you for 5 over, even though you're going 25 over. Many of us have experienced that. However, it's about reducing the traffic stops. And you mentioned in a response a few questions ago about not letting officers, Assemblywoman, thank you, not letting officers just pull you over for anything. And now I'm going to put this on the record because most of the people in this building already know it's become fodder down in the halls here. But I was I was pulled over 3 weeks ago. No traffic violations, no plates or anything expired. And the first question when I asked why I was being pulled over, I was told because I looked suspicious. And then they began to try to build the case through their questioning, most of which I refuse to answer because I know what I have to answer and what I do not have to answer and what they don't have the right to ask me. Even as far as trying to use the fact that I was driving a rental car as additional suspicion. And so what we're getting at, and yeah, the irony of pulling over the chair of Assembly Judiciary because she looks suspicious, when most people tell me that I look more like the Vice President of the United States than someone who would be suspicious. We're talking about, does this bill get to the goal of reducing traffic stops so that these interactions that are happening, that are negative, that are dangerous either for the officer or the person pulled over, or both, does this get to it? We said earlier, to allow discretion, we can do as simple, if you can mail me my parking ticket, why can't you mail me that my plates are off or my taillight's out?
Thank you for that, Chair Miller. To you, through you, Dallas Harris, for the record. I will say here right now that I would consider it a friendly amendment to remove the provisions that allow for a warning. My only hesitation in that is that, as all of you know as lawmakers, this bill has gone through many iterations after many discussions in order to keep our law enforcement coalition on board, as well as some of the more progressive partners. And so what you're looking at is a imperfect but negotiated piece of legislation. So it's not my intent to give officers a workaround, right? In this bill. It was my goal and is my goal to allow officers to continue to do their job safely and ensure that the roads are safe. And if this committee, as I think I'm hearing, would like to remove those provisions, that is a discussion that I am more than willing to have with the stakeholders.
Vice Chair, do you still have your question?
Yes, I'll make it quick.
Thank you.
Thank you, Chair. Good morning, Senator, Mrs. Mosley. I believe you stated this information earlier, and I apologize. I was trying to take notes and listen. Sometimes I don't do that very well. Can you tell me how many other states have passed legislation such as this?
Chair Miller, through you to Assemblywoman Marzola, Lisa Mosley, there is only one other state, that is Virginia. There are jurisdictions, there's Philadelphia, there is Pittsburgh, and San Francisco, and the state of Virginia. Nevada would be the second state.
Thank you. Thank you, Chair.
And just to clarify that, in Virginia, if you know, in Virginia, is it no making stops on these, or is it a making stop with discretion to give a warning for?
Lisa Mosley, Senator Harris is saying yes, but I believe we have Mr. Cole still on the line from Virginia.
Mr. Cole?
And I'm pretty sure he could answer that since he was part of the legislative body that passed the legislation.
I am still present.
Hello.
What I would say, the bill, if I remember from my recollection when we passed the bill in 2020, it is that they could not be stopped as the primary offense. They could give them tickets once they were stopped for a major offense, and then give them a ticket from that after the fact, but it could not be the primary reason for a traffic stop.
Thank you so much for that. And with that, I will go ahead and open it up for testimony. So those that are in support of Senate Bill 296, please come forward.
Good morning, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office, testifying in support. I think there's two things to consider with this bill. There's both a public safety aspect for the general public and then officer safety. And both those things, I believe, are balanced. As written, of course, we would not mind taking out the discretionary stops, but I'll give you a scenario. In my neighborhood, which is one of the more populous neighborhoods for Black and Latinos in the city of Reno, I often see people who are commuting through the center of town to get to the freeway speeding near my house, significantly speeding near my house. They speed through a school zone, they speed through the residential neighborhood to get to the freeway, and I have never, in the last 5 years, seen a single person pulled over for traffic violations on that street for speeding, when I see reckless driving frequently by people who don't live in that neighborhood. Now, on the other hand, as a public defender, many of my cases start with two things, either minor traffic violations, and this other thing is technically a traffic violation, but it's patently absurd to me, riding your bicycle on the sidewalk. The amount of cases that I have seen where the individual was stopped for riding their bicycle on a sidewalk, I can't quantify that. I think it's important when we consider that traffic stops, it's not that they can be dangerous for police officers. They are dangerous for police officers. Statistically, a traffic stop, and they are trained on this, is the most dangerous situation that they can find themselves in. Now, there's a population amongst our communities that is also true. Both of those things can exist at the same time. And so we want to set the tone and say, let's try to reduce those. What I would love is if police officers were told, hey, we want to focus on traffic violations that actually make our communities more dangerous. The tone and say, those are things we can focus on, and let's not focus on these other things that don't pose a danger. And with that, we support. Thank you.
Thank you. And I'm going to need to keep everyone to 2 minutes because our next bill I'm sure is going to have a lot of questions as well.
Good morning, Chair and members of the committee. For the record, my name is Annette Magnus, and I'm the Executive Director of Battleborn Progress. We're here today in support of SB 296 and would like to state that this bill will make it so things like registration requirements and stopping individuals for low-level traffic violations can also, stopping individuals for low-level traffic violations can also have a significant negative consequence, such as escalating minor incidents into more significant confrontations, leading to unnecessary use of force, injury, or even death. Furthermore, this bill will address these issues by limiting the ability of police officers to stop individuals for low-level traffic violations. This would promote fairness and equality and reduce the chances of unnecessary confrontations between law enforcement and citizens. I will just note, in January, I was pulled over because my brake light was out. My husband and I had been working on the brake light for 2 months. Fun fact, in some cars, if the license plate light goes out, so does the brake light. We had to spend over $400 to get this fixed because of the type of lights in my car. When I was pulled over, I thought the light was on because we had been working on it and didn't realize it had gone back out because clearly we didn't have the fix for it yet. It was 5 a.m. on Mountains Edge Parkway in the Senator's District, and I was headed to the gym. I was scared, and I'm a 38-year-old white woman who thought I had fixed the issue and knows my rights and the law. I couldn't imagine if my circumstances were different. People make mistakes, car lights go out, and cars are not always simple or cheap to fix. This just makes sense. Please pass this critical bill, and I thank my senator for this legislation.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office. I'd like to thank Senator Harris for working with all the parties on this bill to try to bring a piece of common sense legislation that tries to strike the right balance in this. I'd urge this committee to pass this bill.
Thank you. Not seeing anyone else here in Carson City to support. Is there anyone there in Las Vegas? I do see. Okay, I do see someone behind that infamous pole. Just not sure if you want to testify in support or not. We still see you, but okay. You can just observe. Perfect. There you go. All right, with that, broadcasting, will you open the lines, please, for support of the Senate bill?
To provide testimony in support of Senate Bill 296, please press star 9 now to take your place in the queue.
Tanya Brown, TONJABROWN, advocate for the inmates and the innocent. We support this bill. We echo the previous comments and would just like not been touched on, which I think would be beneficial in passing this bill. And that would be, we all know about domestic violence. Imagine a victim being pulled over and then having to come home to her abuser to tell her abuser that she had been stopped and got a ticket. I think this would be a reduction in bringing down domestic violence. Also, I want to make a note. Some years ago, my daughter was pulled over for I believe it was a brake light. It was a warning. The officer did not, he was very pleasant with her, did not ask for her driver's license or anything, just gave her a warning, and that was fine. However, she had some female white girlfriends in the car. She also had male Hispanics in the car. One was her boyfriend, who later became her husband, and his friend. Each and every one of them, the males, the Hispanic males, were asked for their driver's license, and they ran a check on them. Now, I have Hispanic grandchildren, and I don't want to see this in the future, and I believe this bill would eliminate that issue, too. And then I just want to remind you about Stephen Laurel. He was the veteran that came through Nevada, was pulled over by the Highway Patrol on a traffic stop. They wound up seizing $87,000 of his money, and he's in litigation over that. So we support this bill. Thank you.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was killed by Reno Police and Washoe County Sheriff's Office. I'm calling in support of SB 296. It's not hard to believe that a community member could end up dead over a broken taillight in a vehicle. LBMPD did kill Byron Williams for riding a bicycle without a headlight. I could not make it through the 400 plus deaths during interactions with law enforcement in Nevada, but I did identify James Tedora, whose interaction started over a broken taillight and turned out into a shootout with LVMPD. Other deadly traffic stops include Aaron Wesley, he was white, Matthew Scott Patton, he was white, Demontra Boyd, she was black, Junior Davis Lopez, he was Latino, Humberto Vera Muniz, Latino, David Lee Kuhn, he was white, Matthew Gibbons was white, Kyle Zimbelman was white, all started with a traffic stop. Please support this bill. Thank you.
Hi, my name is Val Thomason. I'm with the Las Vegas TSA, and I'm speaking in support of this bill. Over a year ago, a little bit, my son was in the car when his father was pulled over for late registration. My son's father is black and formerly incarcerated. And as soon as he was pulled over, the officer pulled him out of the car by physically opening the door and yanking him out of the car. He, of course, was scared and reacted like someone who was scared. And that interaction ended with the officer putting his head through a glass windshield. That was in front of my 4-year-old son, who was permanently traumatized by the event, and to this day still asks me if the police are coming back for his father. And honestly, I can't tell him no, because in the 6 years that I've known his father, I've seen him pulled over no less than 40 times. The majority of those times, he went to jail. Because when you're pulled over, they don't actually have to prove that you committed a crime to put you in jail. You can go to jail for several days or several weeks until a judge dismisses the case. That's long enough for you to lose your home, long enough for you to lose your job, or like one of my good friends who is a single father, long enough to lose your child. Thank you.
Ma'am, are you still there? Did we get the organization she was from? Was it? I don't want to put that on the record, though, if we're not sure. Are you still there?
Yeah, I'm still here.
Yes, I just want to make sure we're clear on the organization you were from.
Yes, the Las Vegas Democratic Socialists of America.
Okay, thank you. Thank you. Next caller, please.
There are no other callers to testify in support at this time.
Okay, thank you. Then I will open it up for opposition of Senate Bill 296, starting here in Carson City. Not seeing anyone. Is there anyone in Las Vegas? Hi. Please make sure to state your name clearly for the record and spell it, please, so we have it correct.
Yeah, my name is Al Rojas, A-L. Last name is spelled R-O-J-A-S. I live in Senate District 12 and Senate District Assembly District 12, Senate District 21. Before I make my statement, I want to tell Senator Harris I have the utmost respect for her, and I know she is concerned about our community. I want to tell you that I'm Latino. You know, I could probably be the new term that's probably going to be on the records pretty soon, Afro-Latino. I don't think I'm Afro-Latino, but I could be. And I'm 63, and I hardly ever get pulled over. There's probably one incident where I got pulled over, and I support the police. I'm a staunch supporter of the police, especially here, Metro here in Las Vegas. And I later found out, I read up on the law, and I got informed. And I think our Fourth Amendment is very clear that an officer can pull you over. There's a suspicion. I watch television every night. My favorite program are the crime programs. Many times we found big criminals that are in doing crimes. Keep in mind that 10% of the people commit 90% of the crimes. Is that correct? Yeah, that's correct. 10%. So a lot of these times, pulling somebody over is going to lead to something else. Now, there are mechanisms. If you feel you're not being treated properly by a law officer, you say, hey, hold on, let me speak with your supervisor. Okay, there are some officers that kind of push the law, but there are ways that you can file a complaint, you can cooperate, and then later make a complaint. There are processes for getting officers out that are not doing their job properly. But to limit, especially with crime going high, to limit that an officer can pull you over. If there's something suspicious, they can pull you over. The Fourth Amendment's very clear on that. So my answer is, as citizens, we got to start looking up our rights. Go look up on the internet, what are your rights when you get pulled over? If you get pulled over, something wrong happens to you, call up your law enforcement. Hey, you know what? What can I do? Is there a manager I can call over there? Look up on the internet. Some of these lawyers are getting pulled over. I think the laws are very fair. I don't think we should be limiting them. I'm supporting the police. And if you're suspicious, you should be pulled over. If you got nothing to hide, then take care of it. Now, if you got problems, when you go get your oil changes, you should have your lights checked on your car. I learned something today. Okay, go over there. I want you to check all my lights, make sure everything's working fine. I just saw something on the TV yesterday that a lot of people are wrong-way driver crashes because some of these cars people don't turn their lights on when they're driving. So I'm totally against this bill. I'm supporting the police. I want them to do their job. And we all have to take more responsibility in being law-abiding citizens. And thank you, Ms. Harris. I appreciate everything you're doing for our communities. That's all I got to say.
Thank you so much for your testimony. Not seeing anyone else physically there in Las Vegas. Broadcasting, will you open the phones, please?
There are no other callers to provide testimony in opposition at this time.
Thank you. Then I will open it up for neutral testimony of Senate Bill 296 here in Las Vegas.
Good morning, Madam Chair and members of the committee. For the record, my name is Pamela Del Porto, Pamela Delporto, and I'm Executive Director for Nevada Sheriffs and Chiefs Association. I want to thank the bill sponsor for multiple meetings and the willingness to meet with the stakeholders on this bill. I'm here today to testify in the neutral position, and thank you for your time.
Good morning, Chair Miller and members of the committee. My name is Beth Schmidt. I represent the Las Vegas Metropolitan Police Department, and we are here in neutral on SB 296. I want to thank Senator Harris for considering all stakeholders and all of our concerns, and because of this, we are at neutral today.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Clark County District Attorney's Office. We are neutral on SB 296. And I do want to thank Senator Harris. We had many discussions on this bill over the course of almost 2 months, and that has got us here to the position of neutral. Thank you.
Yes, one final thing. If Assemblywoman Summers Armstrong, would you like to ask your question? Well, you know what, let me stop. Is there anyone on the lines for neutral? Broadcasting, is there anyone on the line for neutral?
There are no other callers to testify in neutral at this time.
Okay, thank you. Then I will go ahead and close testimony. Assemblywoman Summers Armstrong?
Thank you, Madam Chair. If Ms. Schmidt could just answer the question that I had posed earlier about what information is available when they run plates.
Beth Schmidt, representing Las Vegas Metropolitan Police Department. The answer would be when we run a plate. So we can see what DMV has in there. So if, for instance, you and your husband are both on that registration, it would just come back for one person. So it would come back for the first person listed. And so it would be the status. So if we're looking at 30 days, if it said that it had expired 23 days ago, we would see that. So you see what the expiration date is. And now whether that'll be up to DMV if this bill goes through, that will be up to DMV whether that is considered expired at that point. If they add the extra 30 days, that will be their decision. So we will see the DMV return. So in the instance of where you have the sticker, and I think it was Assemblywoman Newby who said you have the sticker and you forget to put it on, we would be able to see that the car had been, that Assemblywoman Newby had registered her vehicle and just hadn't put the sticker on yet.
Quickly, because the Senate Majority Leader still has a bill.
Thank you so much.
And a concise response, please. And concise question.
So it requires an additional, thank you, Ms. Schmidt, for that information. So are you implying or saying that it requires an additional background in order to get any other type of background, like a warrant or anything that is not included in this DMV? You'd have to run something else?
Beth Schmidt, for the record. What would come up is if the plate is run, whether we call it out or we type it in, what would pop up on the computer is the local criminal record, and that would show for the registered owner only, and any DMV information.
And you're welcome. I'd like a brief follow-up to that. Then how do you know, in a case where you can run plates without pulling someone over, how do you know which person's actually driving the car?
Beth Schmidt, for the record, you don't. And that's part of your investigation. So we don't teach that just because there's a warrant on that you would pull the person over.
Okay, thank you. With that, I will welcome the bill sponsor up for a brief closing remark.
Thank you, Chair Miller and members of the Assembly Judiciary Committee. Dallas Harris for the record. In closing, I just want to thank the committee for a very robust discussion and hope that we can answer any additional questions that the committee may have. And I just want to thank you all for your time.
Lisa Mosley, Madam Chair, committee members, just want to say again, thank you for hearing this bill, and thank you for all of the questions and the dialogue. And also, Chair Miller, I want to just express my concern for you that you were pulled over and questioned the way you were, and also my frustration. I have had that experience, which is part of the reason why I'm at this table today. I've had lots of interaction behind these kinds of infractions, administrative, and warrants and tickets and not being able to pay. And I'm happy to say that today I don't have that issue. But I'm empathetic to anyone that does and that has had that issue. And so I wish actually we could take this bill in its first iteration. That would be awesome. And I appreciate the work that Senator Harris does in talking with everyone and taking everyone's concerns into consideration. This is a first step. And as with any first step, you have to implement it and see how it plays out. And once that does, we can see where the holes are. You know, as an example of that, and I know the majority leader has to come and give her bill, so I'll try to be a little bit. I was just thinking of body cameras on police when they first came out, the resistance to those. But now they're welcomed on all fronts. And so I liken this bill to something, let's implement it. Let's see how it plays out. Let's see where the holes are. And let's see what we need to do next legislative session to make it better. And I promise you, if this body is willing, and I will, as the Fines and Fees Justice Center, be happy to find a sponsor for a bill that will send notices to people when they have these infractions versus pulling someone over. So, Chair Miller, I probably will be coming to you.
Thank you so much for that. With that, I will go ahead and close the hearing on Senate Bill 296. Our next bill is Senate Bill 309, sponsored by our Senate Majority Leader, Canizaro, and co-presented by Saha Sahali. And with that, this bill makes various changes relating to health care. And so, Leader, whenever, I know it might take a moment to get settled in, but whenever you are ready, please proceed.
And I want to thank you, Madam Chair, and members of the committee for having us this morning, and appreciate your indulgence as we are moving between committees and votes in those committees. For the record, my name is Nicole Canizaro. I serve as a senator from Senate District 6 in the northwest portion of the Las Vegas Valley, and also as your Senate Majority Leader. I am very pleased to be here this morning to have the opportunity to present to you Senate Bill 309, which creates the crime of fertility fraud and includes additional provisions related to that crime. As you may already know, there have been several high-profile cases of fertility fraud reported in the news over the last several years. And fertility fraud occurs in the field of assisted reproduction when a fertility doctor inseminates a patient with his own sperm without the consent of his patient, or when a donor's eggs are used without her consent. Those are the two most common types of fertility fraud, but as you will see in Senate Bill 309, there are additional definitions that are included in that. I am very excited to have with me here today my very brilliant intern who's been doing a fantastic job in our office this legislative session, Saha Salahi, who is a student at UNLV studying communications and media studies with a public policy minor. Before we go over the bill, Madam Chair, with your permission, I would like Saha to give the committee a little bit more background on fertility fraud and the reasons for bringing this bill forward, and then she'll turn it back over to me. I'll do a walkthrough of the bill, and then we'd be happy to take any questions that you may have.
Good morning, Chair Miller and the members of the Assembly Committee on Judiciary. My name is Saha Salahi, that's S-A-H-A, S-A-L-A-H-I for the record. With your indulgence, Chair Miller and members, I'd like to speak briefly about the 1991 Nevada Physician of the Year. Dr. Quincy Fortier was a Nevada fertility specialist who had been considered an esteemed member of his field as a commander of a medical reserve unit at Nellis Air Force Base. He had been elected to the Southern Nevada Memorial Hospital Board of Trustees and was instrumental in the growth of Faith Lutheran Academy. Despite his medical expertise and high regard within the professional community, the doctor inseminated his patients with his own sperm, without their knowledge nor their consent. Recently, through the use of DNA testing kits, many dozens of families concluded that decades ago, their doctor violated them during one of the most vulnerable visits to his clinic. Dr. Fortier's lawyers use the defense that Nevada law doesn't explicitly say doctors cannot use their semen on the patients to aid in fertility treatments. In the past few years, Indiana, Iowa, Arizona, Arkansas, Colorado, Kentucky, Utah, Texas, and Florida have enacted laws on fertility fraud. As of 2019, doctors who use their reproductive material to inseminate patients in Texas are able to be found guilty of sexual assault and face a felony charge in the second degree. In March 2021, the state of Utah decided to use the use of a doctor's reproductive material without the patient's consent is a third-degree felony. California has had laws enacted since 1996, which constitutes fertility fraud a crime, punishable by a sentence of 3 to 5 years and a fine of up to $50,000. It's unsettling to find out that this human rights violation is currently legal in our state, and that doctors have never been charged for participating in such a violation. Nevada has recently been known for being the first state legislature to have a female majority in the nation and putting women's rights at the forefront of policymaking. However, the lack of recourse for this heinous crime has been more than frustrating, it has been shocking. Until legislative changes are enacted in Nevada, it's feasible that a doctor could continue to violate their patients with fertility fraud today. It is my hope that patients in the state never have to experience that of the patients under the care of Dr. Fortier. The doctor's case ended before a judicial decision was reached due to his death, leaving a loophole in Nevada law open, an opportunity and a duty for our legislature to close it. With that, I'd like to turn it back over to Senator Cannizzaro to further explain how Nevada could finally join other states in explicitly criminalizing fertility fraud.
Thank you, Madam Chair, members of the committee. Moving to the bill, I will go through a section-by-section analysis. Sections 3 and 4 define the terms of assisted reproduction and human reproductive material for the purposes of the bill. Section 5 creates the crime of fertility fraud as a Category B felony, which carries a prison term of 2 to 15 years and a fine of up to $10,000. This crime occurs when a healthcare provider knowingly implants his or her human reproductive material in a patient without their express consent, or when a healthcare provider knowingly uses human reproductive material other than that was expressly consented to by the patient. Section 6 creates the related crime of fertility fraud in the instance of a person other than a healthcare provider who knowingly conveys false information to a patient concerning the donor or the human reproductive material to be provided to the patient. That violation is a Category C felony. Both Sections 5 and 6 provide for the notification of appropriate licensing boards by the Attorney General upon a conviction for either of those crimes. Sections 7 and 8 provide that a civil cause of action may be brought within 3 years after a victim discovers fertility fraud, and provides that a victim may also be a spouse, a child, or a donor, and that each child born as a result of that fraud constitutes a separate cause of action. Section 9 adds fertility fraud to the list of sexual offenses for which a court is prohibited from ordering a victim to take a psychological or psychiatric exam, and Sections 10 and 17 add fertility fraud to the list of sexual offenses for which lifetime supervision is required. Sections 11 and 12 add fertility fraud to the list of sexual offenses for which an offender must undergo a psychosexual evaluation and for which a court is prohibited from granting probation or a suspended sentence unless that psychosexual evaluation comes back as less than a high risk to reoffend. Section 13 provides for a victim and a witness notification upon conviction, as is done with other sexual offenses, and Section 14 prohibits the sealing of records for this particular offense. Finally, Sections 19 and 20 provide that a healthcare facility shall not provide a patient with human reproductive material except in accordance with an agreement entered into between the patient and the facility and the donor and the facility. A violation of these provisions carries a civil penalty of $10,000 per violation in an action to be brought by the Attorney General on behalf of the state. A facility that violates these provisions is also subject to license suspension or revocation by the Division of Public and Behavioral Health, Department of Health and Human Services. That concludes my walkthrough of the bill, Madam Chair and members of the committee. I do believe that this is an important piece of legislation for families who are struggling with fertility and who appear at a facility, or someone who is offering to undergo what can be a very intrusive process to donate eggs, or even someone who is donating sperm, in order to allow for families to then have a baby, for them to enter into a facility, for them to trust in a medical provider, for them to put their faith that this process is ultimately going to culminate in the establishment of a family that they have been thus far unable to procure. The time, the emotion, the money that goes into all of this, for them to then be taken advantage because someone is just so completely narcissistic that they want to utilize that very vulnerable state for their own purposes, I believe deserves a very high penalty. That is reflected in this bill. I believe that we have a duty to ensure that we do not have a loophole where someone can come in and say, well, it wasn't expressly prohibited by Nevada law, so good luck suing me, taking my license, or finding some sort of criminal action. For me, this type of action is akin to a sexual assault. This is the violation of someone's most basic needs. And for us to not take action to ensure that should something this heinous happen in Nevada, we don't have the tools to properly address it, I think is us denying our duty to the citizens of Nevada. And so I recognize that this may be a rare circumstance, but I think in this rare circumstance, there is a compelling need for both a tough penalty and also some provisions that would allow for civil recovery for families who were told one thing and then experienced a complete another in the course of what can be an extremely emotional and very difficult process, all just to have a family. And so, Madam Chair, with that, we would love to answer any questions that you and the committee may have. Thank you.
Thank you for that, Senator. And I don't know if your adjectives are even really get to just how despicable this is and how vulnerable our families are, and just heinous and unimaginable. Because again, this is one crime we give factors for crimes with intent and without intent, and there's no accidental way that this would happen. So thank you for that. Our first question comes from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. I have a question about the statute of limitation and maybe a possible request for an amendment. So with the statute of limitation, I'm at the top of page 6. I don't even know which section that is, but so it says that the action pursuant to Section 8 shall be deemed to accrue upon the discovery by the aggrieved party of the facts constituting fertility fraud. I would suggest that maybe that be opened up a bit, because I could see where you could have a family where they realize there's been fertility fraud, but maybe they were planning to use an anonymous donor anyway, and so they don't want to go through the hassle of going to court. They don't want anyone to know what's happened, so they don't want to raise an issue, and they're not necessarily planning to do anything. And then a few years later, or a few months later, well, I guess it would be years later, they find out the material passed down had a genetic disease attached to it or something like that, and then there needs to be care for the child. But maybe now they've passed up their statute of limitations. So I guess I want to confirm, is it at the time that they found out that the genetic material isn't the genetic material they expected, or the time they found out that perhaps a genetic disease was passed down to them? And if you would be willing to extend it to allow for such a situation.
Thank you for the question, Assemblywoman Cohen. Through you, Madam Chair.
Please go direct.
Thank you. To you, Assemblywoman Cohen. Nicole Canizaro, Senate District 6. The way that this reads currently is that it's within 3 years from the discovery that the fertility fraud had occurred. But I would certainly be open to an amendment, because I think you have highlighted one of the toughest parts about this, is that a family who is maybe trying to conceive a child may not be sharing with that child who is young, or with friends and family, that something like this had occurred, because they're trying to preserve their family union. They're trying to make sure that that child feels included and part of the family regardless. because now that child is with them, they have given birth to them, they are raising them. And so I think that there are a lot of very sensitive issues that go into this, and would be certainly open to an amendment that would allow for some additional leniency, because I do think there is more than just, we discovered there was fertility fraud and therefore now, we may have a cause of action for a civil suit and different things that could motivate that, and don't want to deny families that ability to pursue that action.
Thank you. Thank you for that. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you so much for being here this morning and bringing this really critical bill, because I think I agree with the Chair that despicable is a good way to describe this. So my question is on sections 4 and 5 on page 3. I know it creates the crime of fertility fraud, and they says knowingly implants his or her own human reproductive material in a patient without their consent. But then right above, it says human reproductive material means a gamete or human organism. And so I just want to make sure, I am obviously not a doctor, and I just want to ensure that means like any genetic material at all, sperm, egg, embryo, everything falls under this.
Thank you for the question, Assemblywoman LaRue Hatch. Nicole Cannizzaro, Senate District 6. Yes, the way that I read these sections, and certainly very capable legal counsel with the committee would be able to correct me if I am wrong. But when we talk about assisted reproduction in Section 3, that's already defined in NRS 126.510. That includes things like donating eggs, sperm, other reproductive material. And then when we talk about human reproductive material, that also would be where you're in a situation where you're not just donating it, but that you're also then receiving that in the form of an embryo for the purposes of pregnancy and generating a child. So I believe that would all be covered under this. And it also, this bill also has the provisions in it for ensuring that there's not knowingly false information provided to either a donor or to a patient who is receiving that reproductive material. And I think when you read all that together, it would encompass everything.
Thank you so much for that, Senator. And with that, as soon as you said paperwork, it adds to the felony because those documents would have been falsified. I just wanted to follow up with the Assemblywoman. Would that, when we're talking about reproductive materials, would this include things like stem cells and placenta, or are we only talking about for the purpose of reproduction?
Thank you for the question, Madam Chair. Nicole Cannizzaro, Senate District 6. The way that Senate Bill 309 reads, this deals specifically with human genetic material, and so in the form of sperm, in the form of eggs, and for the purposes of fertility. And so this is, I think, while trying to make sure that we're covering any fertility treatment that you may be receiving or that you as a donor are contributing to, it really is just dealing with these very specific instances regarding fertility.
Thank you. Our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you, Senator Cannizzaro, for this. This is a really sensitive issue. Those of us who have gone through this, I can't even imagine if someone had done this. It's painful, and it is frustrating and sometimes humiliating, and to think that this happened to someone is just horrible. Can you tell me in Section 1, subsection 5, and paragraph 2, you have a fine of $10,000. Can you just give background on why $10,000? Does this track with other penalties? And under the circumstances, would you believe that maybe a higher penalty might be appropriate here?
Thank you for the chair, Assemblywoman Summers Armstrong. Nicole Cannizzaro, Senate District 6. I, first of all, just have to acknowledge that your sentiment is entirely correct. This is extremely, for anybody who would even be the subject of what we are talking about in Senate Bill 309, has probably gone through some very significant hardship to even find themselves in that position, because you don't come lightly to fertility treatment. That's just not how that goes. Most of it is not covered by insurance, so you're also expending an exorbitant amount of money. And it is not successful on the first try many times. And so the emotional and the financial hardship and the strain on the family and on relationships is real. And then to find that you have been told something by a medical provider that is just not true in the course of or during or even after a pregnancy, to me is just unimaginable, but has happened to so many Nevadans that it's astounding that we even have to have this discussion. And so I agree, and the reasons for this being a higher penalty in terms of the length of time and the category I think are appropriate. With the fine, the $10,000, that is very typical for a Category B felony. Certainly would be open to increasing that because I do think that this is something that is very calculated and takes a certain degree of, I think I refer to it as narcissism, which is maybe the best way that I can describe it in the setting that we are in an appropriate fashion. And so I would certainly be open to an increased penalty that is in there. It is in alignment with many Category B felonies of a $10,000 fine.
Assemblywoman Newby, do you have a question?
Thank you, Madam Chairwoman. You read my mind. My question is, this crime being, if this passes and becomes law, doesn't necessarily preclude then the families from seeking civil remedies as well because $10,000 fine is a drop in the bucket compared to the cost of fertility treatments. So maybe if you could address that.
Yes, thank you for the question, Assemblywoman Newby. Nicole Canizaro, Senate District 6. So you are correct. I mean, $10,000 when you're talking about fertility treatment would be extremely cheap. When you're looking at even very basic intervention, it can be quite expensive. So in this section, in Section 5, when it's talking about the $10,000, that's a criminal penalty. There is in this bill, if you'll give me just a moment to get to it is in Section 8. It specifically discusses Section 7 that we discussed earlier with Assemblywoman Cohen identifies the statute of limitations that would be for filing a lawsuit. And then additionally, there are provisions in Section 8 that allow for not only actual damages, but also punitive damages to be awarded by a court in the event of a civil lawsuit. There are also provisions for recoveries of attorney's fees for the prevailing party should that be part of the civil lawsuit. And so this would be more than $10,000. It would be up to a court, right? And it would be up to the parties in that courtroom to talk about actual damages, which could include things like what you paid for that fertility treatment during the course of that procedure, and could include punitive damages, which are intended to punish the offender, and in order to ensure that, when we're talking about appropriate behavior, that we're incentivizing good behavior and deterring bad behavior. And in the civil context, those punitive damages could be awarded by a court and would be up to a jury or potentially a judge to award those. And so it would allow for the actual recovery of those actual damages, out-of-pocket expenses, and then also any punitive damages. So it would be higher probably than $10,000 would be my guess, since it does allow for the actual damages, and like we discussed, $10,000 would be a very small amount for fertility treatment.
Thank you for that. I don't see any additional questions from members, so I will go ahead and open it up for testimony. Anyone here in Carson City that would like to testify in support?
Good morning, Chair, members of the committee. For the record, my name is Serena Evans, SERENAEVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. We'll just keep it short, and that's say fertility fraud is reproductive coercion and takes away somebody's ability for informed consent, and so we are in strong support of this bill. Thank you.
Thank you so much. Not seeing anyone else here in Carson City, is there anyone there in Las Vegas that would like to testify in support of Senate Bill 309? Not seeing anyone approach. Broadcasting, will you open the lines, please?
To provide testimony in support of Senate Bill 309, please press star 9 now to take your place in the queue. There are no callers choosing to provide testimony in support at this time.
Thank you. With that, then I will open it up for opposition testimony to Senate Bill 309. Not seeing anyone here in Carson City. Is there anyone there in Las Vegas? Broadcasting, will you open the lines?
To provide testimony in opposition of Senate Bill 309, please press star 9 now to take your place in the queue. There are no callers choosing to provide testimony in opposition at this time.
Thank you so much. Is there anyone in neutral of Senate Bill 309? Not seeing anyone here in Carson City. Is there anyone in Las Vegas? Not seeing anyone. Broadcasting, will you open the lines, please?
To provide testimony in neutral of Senate Bill 309, please press star 9 now to take your place in the queue. There are no callers choosing to provide testimony in neutral at this time.
Thank you so much. Then with that, I will welcome the Senate Majority Leader, who is waving that not much more to say on this topic. Thank you so much. With that, I will go ahead and close the hearing on Senate Bill 309. Our last order of business today is public comment, where you will have up to 2 minutes to make a comment under anything under the purview of this committee, but not related to the bills that we heard today. So if there's anyone here in Carson City? Not seeing anyone, but I do see someone in Las Vegas. You will have up to 2 minutes, sir. Please proceed. Make sure.
Yeah, my name is Al Rojas, A-L, first name, last name R-O-J-A-S. I live in Senate District 12, Assembly District 12, Senate District 21. I wanted to address something in the field of education. I know that they're throwing $3 billion into education. And though I do support school choice, I am also concerned about our public schools. As you know, keeping kids in school past the 9th grade will reduce their life of crime by over 90%. If a kid is out of school after the 9th grade, his chances of being a criminal are over 90%. And these people become adults, and it's harder to rehabilitate them. As an advocate for community safety, which is one of the reasons why I stepped out of the woodwork and got involved in my community, I'm seeing that that's a big issue. And what's happening is that it turns out that most of the kids, a higher percentage of the kids have mental problems that are in school. We need more counselors. That's what I'm getting at. We need to have those $3 billion. I feel, I've been doing some research. I don't know all the details, but the session is about to end, so I got to get a word in for the record. We need more counselors in the public schools and in the charter schools. One counselor per 250 students is the recommended number from what I'm reading, and there is no law that will keep those counselors as counselors. In other words, if there's not enough teachers, they will put them in a teaching role. And so I'm advocating that we look at that, because we got to keep the kids in school if we want to have a safe community, if we want to diversify our economy. All of these goals that we're setting for Nevada, which I'm hearing from our mayor down here, Goodman, our biggest growth is going to come in the next 10 years.
Okay, thank you, sir. Your 2 minutes are
up.
up.
Kids in school.
Thank you so much.
Thank you very much.
Is there anyone else there in Las Vegas? I don't see anyone, so broadcasting, will you open the lines, please?
To provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Graham for the record, ANNEMARIE. Grant calling again to urge you all to have Attorney General Aaron Ford conduct an investigation into the constitutional violations occurring at the Washoe County Sheriff's Office. You all should have received an email, and I'm going to read it. It says this letter is in regards to, excuse me, numerous communications that your office and the AG have received over the past 16 months regarding complaints of what has been an ongoing problem at the Washoe County Jail that has brought many victims and those who know about its policies, practices, and procedures together, demanding at the most critical time answers. This past weekend, a communication was brought to the attention of the Public Defender's Office regarding 2 inmates whose criminal cases have very equals given the delay in both and the circumstances of their arrest that involve excessive use of force in one, and in the other, lethal use of force that rendered the inmate incapacitated in a hospital for several weeks. Both gentlemen are being held unlawfully against their will, and in order to silence them with the information that they possess regarding illegal human trafficking and RICO violations involving domestic police in northern Nevada region, it must facilitate an immediate investigation into their cases, which have been ignored by the Public Defender's Office in Washoe County representing them, as well as many suspects in the direct involvement of the Reno, Nevada courts and Reno law enforcement, especially the Washoe County Sheriff's Office, attempting to cover up what amounts to very serious crimes, both state and federal. Enclosed with this communication are audio recordings, emails to the attention of attorneys who are both directly violating their duties to both their clients and the duties to the officers of the court in reporting the circumstances of both defendants being deliberately and maliciously held against their will. The basis for the 2 of them reaching out to us is based on formal complaint that was brought to the attention of the U.S. Department of Justice Civil Rights Division earlier this year that chronicles the abuse, negligence, and neglect by the personnel that manages the facility and the treatment to the inmates. I guess I'm at my 2 minutes. Is that what you're going to say?
Yes, you are.
Yep, I'm done. Thank you.
Thank you so much.
Caller with the last 3 digits 927, you are unmuted on our end and may begin.
Yes, my name's Aline Carino, and I'm calling to make public comment in regards to the Washoe County Sheriff's Department and the jail. We would really like you to investigate or do something with the inmates, look into their conditions that appear to be inhumane. And, like they're cold, they can't get extra blankets or thermal underwear, things like that. And I say that if they're not following the rules or if they're violating people's constitutional rights, I would like to have all of their federal funding ceased. And we're going to be looking into that because they're actually, their rules and they're not following them if people are being harmed in their facility. So I would appreciate it if you would all take that into consideration. Thank you.
Tanya Brown, TONJA, BROWN, Advocates for the Inmates and the Innocent. We echo Ms. Grant's comments and Ms. Carino's comments as well. We would also like to make note that recently one of the defendants appeared in Washoe County District Court, and even the judge made a reference to the defendant not looking well, and over the period of months that he has seen the defendant, his condition has deteriorated. And this should be a concern for everyone. And we would like for you to think about that in possibly future legislation in 2025. So that could be a remedy as well. Thank you.
If you have recently joined and would like to provide public comment, please press star 9 now.
Hello, this is Robin Austin. I live in Denver, Colorado, and I would like to comment. I I echo the comments of some of the previous callers about the Washoe County Sheriff's Department. I have reports, reliable reports from trustworthy people that have made it clear that inmates are being abused in this prison system. Their arms are being put behind them, and they're put in a position that has caused damage to them. They're not given medical attention in any kind of timely way. Their medicines are not being administered in a way that is prescribed by physicians. They are being deprived of warm clothing and sufficient blankets to keep warm in a very cold environment. People who have requirements, they have food with their medicine or not, those are not being honored. These are inhumane conditions, and we have laws against cruel and inhuman or inhumane punishment, and yet this is going on every day in this system. And I would like for you to mount a true investigation of what is going on there, because we really should not be a society that permits this kind of thing to go on. So I'd like to see some action taken. I do not wish for this to be swept under the rug or ignored. This is really an example of something that we've got to address nationwide, but let's start right there, because I know of the violations going on in that environment. Thank you.
Again, if you have recently joined and would like to provide public comment, please press *9 now. Caller with the last three digits 876, you are unmuted on our end and may begin.
Yes, good morning, ladies and gentlemen of the Nevada State Legislature. My name is Stuart Evans Santee. I am a 49-year resident of the state of Nevada. 48 of those years have been in northern Nevada. I'm a 30-year law enforcement veteran, retired in good standing. I was a state trooper for the Nevada Highway Patrol for 20 years, most of that being here in northern Nevada, so that's most of my career. I'm speaking this morning on the horrible existing conditions that take place at the Washoe County Jail. And I'm speaking on foundational experience by the fact that I was in that jail from January 2022 until April 13th of 2022, where I personally observed people being mistreated, people not being attended to in a medical capacity. I witnessed a gentleman walking around the infirmary where I was in lockdown for 23 out of 24 hours a day for no apparent reason other than he didn't have a place to put me. He was walking around with an obvious broken arm. He should have been at the hospital. He was one step away from having that broken arm become a compound fracture. I know a lot about the medical profession. My mother was a nurse for 45 years. My father was also in law enforcement. I'm asking the members of the Nevada State Legislature this morning to demand that Attorney General Aaron Ford, and I made inroads to Mr. Ford as well, to demand an investigation into the inhumane conditions that exist at the Washoe County Jail under the tutelage of Sheriff Darren Balin. I know Sheriff Balin very well. I knew his father very well. And I was a former sheriff of a county here in Nevada as well, Mineral County, from December 2013 until January 2015. So again, I'm speaking to you all this morning with conviction. There are serious questions being put forth about the conditions there. And I also observed a man who'd been shot 5 times by Reno police officers who should have been in the hospital as well. I also was set forth upon inhumane conditions. I was in a wheelchair and a walker the entire time I was in jail. I was refused medical treatment from any qualified or quantified medical personnel. And this ridiculous situation continues to go with my co-defendant and friend, Roger Hilligus, who's already been spoken about apparently this morning.
Sir, I need you to wrap up your comments.
I'll wrap them up right now. I'm demanding an investigation by Attorney General Aaron Ford. I'm asking the members of the state legislature to demand Mr. Ford do his job and investigate these conditions. Thank you very much for your time, ladies and gentlemen. Have a great day.
There are no other callers to provide public comment at this time.
Okay, thank you so much. Well, this concludes our business for today. Want to remind members that we need to be on the floor in 10 minutes to begin at 11:30. And I will see everyone tomorrow morning back at 8 a.m. This meeting is adjourned.